It was a shock. It was a shock to see Judge Louis Lyman of the U.S. District Court in Manhattan dismiss Justin's lawsuit. Just as a reminder of how this case got started, Blake Lively went to the California Human Rights Office, the California Civil Rights Department, and she filed a legal proceeding there to try to get Justin Baldoni in some trouble and trying to sound the alarm that he was some sort of a sexual predator. And very clearly, she then provided that document to the New York Times, and they ran with it. And using the allegations of that complaint, they painted him in a very irresponsible piece as a sexual predator, basically just taking the words of Blake Lively, allegations unproven from that document, and perhaps other statements as well, though exactly what else she provided remains unclear. It should have been exposed in the discovery process, where Baldoni will have the opportunity, or would have, to depose Blake Lively, to depose the New York Times, and figure out exactly what happened, how they got their hands on it, what additional statements were made by Blake Lively and or her team to the Times before they ran with that piece. That's now not going to happen because the Times has been dismissed as a defendant and with no leave to refile. So that was on December 20th that we saw that complaint, and the Times then ran an article. By the 31st of December this past year, Blake Lively sued Justin Baldoni, and Justin Baldoni also filed suit against the New York Times, alleging that that piece defamed him. And then 2 weeks later, on January 16th, Justin Baldoni sued Blake Lively, sued Ryan Reynolds, and sued this PR agent, Leslie Sloan, and her company. What's happened this week is this federal district court judge reviewing what's called a 12B6 motion, a motion to dismiss the case without even getting to discovery, never mind trial, has granted that motion filed by Lively and the other defendants against Baldoni. His entire case against her has been thrown out, except for two minor claims for breach of the implied covenant and tortious interference with a contract. So implied covenant of good faith and fair dealing and the tortious interference with a contract, which are based on one smaller allegation made in the in the Justin Baldoni complaint, suggesting that I think this one is based on the fact that Ryan Reynolds allegedly went to WME, this large agency where Ari Emanuel is the owner and chief agent, and said, you need to dump Justin Baldoni as a client, and that he did it. And I believe Ari Emanuel has admitted this happened. I think he was on a podcast admitting that this happened. And the question is whether that can amount to the tortious interference with the contract between Justin Baldoni and WME. Even if they win on that, it's peanuts. Okay, that's not. I'm just being honest with you. As you know, I'm on. Having looked at this very closely, I believe Justin Baldoni is the truth teller, by and large, in this case, and that Blake Lively has either exaggerated or made up the overwhelming substance of her complaint. She wanted to save her own ass after suffering some bad publicity, and she's orchestrated this whole thing, which she thought would give her an I am woman, hear me roar moment. And now, thanks to this judge, she's sort of getting it. But that's what I think this whole thing is about, not about actual harassment by Justin Baldoni of Blake Lively. As we've seen, her complaint against him has fallen apart. I mean, just piece by piece, her scurrilous allegations of what he did to her have proven, in my clear view as an attorney, to be lies. I believe she lied. I believe she lied when she complained that he burst in on her while she was breastfeeding in her trailer. And then we've seen the correspondence between the two of them where she says, come on over, I'm breastfeeding. I mean, okay, it seems you only told us half the story, madam. She was forced to look at porn by these evil producers working with Justin. And they responded that, in fact, and they produced the pictures, what they wanted her to look at was a totally benign, not even PG-13. It's like a G-rated photograph of the producer and his wife in a bathtub after a bathtub birth. No nudity. It's like a beautiful shot of a new baby with the parents. It's like she's insane. This is not pornography by anybody's definition. Now, maybe when we get to trial, she's going to show us some XXX porn that they they threatened to show her or did show her. I doubt it. She hasn't exactly held back in trying to rehabilitate her image. So those are just a couple of examples of how her claim in chief is falling apart. But in any event, Justin tried to fight back by saying she's now trying to smear me, in addition to like not being able to handle some bad PR around the launch of this movie that she brought upon herself and blame it all on me. Now she's gone next level by trying to smear me by filing this complaint with the Civil Rights Division in California, by clearly leaking it to the New York Times and trying to let the country know I'm some sort of a sexual predator, all of which is false. So he fought back. And he fought back not only by going, into a PR stance and unleashing Brian Friedman, his lawyer, and as you know, mine, on the world, but filing a counterclaim against her or claim against her. And that did not work out. So here's how bad it is. Okay, before we get to where this is going, it's very bad. It's the dismissal is very, very bad for Justin Baldoni, at least as of right now, because California has this wacky rule. It's a new rule under a law Gavin Newsom signed in October 2023. It's California Civil Code 47.1. And this was signed by Gavin Newsom. It extends the California Civil Code's definition of a privileged communication in a defamation action to include communications made without malice about an individual's own experience of sexual assault, sexual harassment, workplace harassment, or discrimination, and cybersexual bullying. And what this means is that any defendant accused of defaming someone who then wins, who gets, for example, the case dismissed against her, she's been accused of defaming him in, let's say, a 12b6 motion, and what was at issue was her privileged communication about her alleged sexual harassment or workplace harassment, is entitled to recover attorney's fees and costs, as well as treble damages and punitive damages. Treble means triple. This is what Gavin Newsom did, was said, if you get wrongfully sued for defamation, and the defamation you're accused of is you're a woman accusing somebody of sexually harassing you, and basically he fights back by saying this is defamation, and you as the woman, it could be the other way, but let's just go for, in this particular case, because that's the facts here, that it's the female accusing the male of sexual harassment, that you are not only entitled, if you win, if you prevail against this defamation charge, to your attorney's fees and costs, but we will triple those damages and potentially award you punitive damages to punish him and discourage others like him from bringing such defamation claims in California. Now, that's very bad. This case wasn't in California, but it was governed by California law. And this is brand new. This is one of, if not the first case in which this law has kicked in. And so I don't know how bad this is going to get, because, I mean, her lawyers might have expended $5 million. I've worked at large law firms where you easily expend millions of dollars in fees in fighting a 12b6 motion, or in filing one for that matter. And so it's going to be millions. The attorney's fees are going to definitely be in the millions. The only question is how high. There would also be a question of reasonableness. This judge is not going to say, oh, you spent $50 million, Team Lively. Yeah, okay. Now he has to pay you $50 million and I'm going to triple them. That's not happening. But let's say she has $5 million in attorney's fees. It is not outside of the realm of possibility that he then triples those and awards her $15 million in damages and also potentially punitives. I don't think that's going to happen. It's all within the judge's discretion. And these claims are far from so specious or speculative or without merit that I think that a sane judge would say, I'm going to impose that kind of a punishment or pain on the defendant here. Well, technically in this particular claim, he's the plaintiff. He's the defamation plaintiff against her. I just don't think that this judge is going to do that to Justin, given how strong his defense is to her underlying claims and how his defamation claim against her really was well supported. It was. The reason they've been dismissed is because he recognized that there's a privilege in California to make the claim she's making of sexual harassment under California law if you do it in a legal proceeding. That's really why his defamation claim against her was dismissed. It's not because, he has no grounds to say he didn't harass her, that she's doing all of this to build up her own Me Too cred and trying to make herself into a, feminist hero. He does have the proof of all of that. It's that there's this privilege that covers, according to this judge, her complaint in the California Civil Rights Division or Department. And for that matter, he says it kind of extends to the New York Times. So a reporter, like somebody at the Times, like yours truly, who cites allegations in a complaint, a legal document, generally won't be subjected to defamation claims if you just repeat what somebody's alleging in a lawsuit. And I have to say, as somebody who's in the journalism business, I like that law. I like that general rule because I should be allowed to tell you what somebody's alleging in a court without endorsing it in such that I get sued for defamation myself. But Brian Friedman's lawsuit on behalf of Justin Baldoni, to me, included far more than just allegations that were in that complaint lively filed with the California Civil Rights Department. It was clear to me that what was in that New York Times article included allegations beyond that complaint. And to me, the judge just never squared that circle. He just kind of seemed to gloss over the fact that there had clearly been additional communications between Team Lively and the Times. That's how I read it. He's ignoring that and just saying, the privilege that protects a sexual harassment victim making allegations in a legal document gets her off the hook, and the reporter privilege gets the New York Times off the hook. Father's Day is coming up. Let's celebrate all the great fathers out there who have had such a positive influence on our kids and our nation. You want to celebrate a special dad? How about brightening his day by giving him a gift of Riverbend Ranch steaks? Yes, anybody would love to receive this. Riverbend Ranch has been recognized by the team at Certified Angus Beef as having some of the finest quality black Angus beef in America. The difference in quality and flavor is not by accident. For the last 35 years, the Riverbend Ranch has been raising black Angus cattle with a focus on flavor and tenderness, carefully sorting the genetics to produce the absolute best quality beef. And they raise their beef the old-fashioned way, without artificial growth hormones and without antibiotics. Riverbend Ranch is all about quality. Last year, the Engineering News Record named the Riverbend Ranch Beef Processing Facility as the best manufacturing facility built in the U.S. in 2024. Exceptional American beef, grown and processed in America. For a very special Father's Day, order directly from riverbendranch.com. This is a great gift. Your dad will not be expecting this. This is like, what do you normally get him, a tie? This is a really cool one that he's really going to enjoy, and so are you. riverbendranch.com. Use promo code Megyn to get $20 off your first order. riverbendranch.com, promo code MEGYN. Thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.